Sally was telling me today that she and Philip are looking into IVF. She asked me if knew anything about her property rights.
Property rights? Her house, you mean?
No, her property rights in having IVF treatment. You know, who owns what and what happens to material that's not used.
How does that work? Why would she need to know that? What's she planning to do with it?
It's an important consideration for them. They might want to store sperm or eggs or embryos to help them have the chance of children later on, or in case it takes a few attempts for them to get pregnant. I told her to watch this cartoon that explains what it means. Jessica made it for new admin staff at the reception as a training video. Hello, how can I help you today? I have some questions about assisted fertility treatment, and I heard I need to know about our property rights. I don't even know what that means. I'm a little concerned. That's okay. It's an important issue and one that everyone undergoing a plan for treatment should know about. A donor has certain rights over their property, whether it is sperm or eggs, for example. It has been seen as a bit of an unknown to a lot of people, as laws have been slow in the past to keep pace with evolving medical technologies, but things are clearer now after court cases that have defined rights. Oh, I have done some reading and couldn't find any Queensland laws that say we have ownership of what we donate if something doesn't work out. I mean, I know that my partner makes a sperm donation and it's used with my eggs to make an embryo. But what about the sperm that isn't used or the embryos? There is no specific legislation in Queensland for assisted fertility treatment, but there are strong guidelines and some common law cases to guide us. Common law is law that has been made by judges in a case. It can be used where there is no legislation in place. That sounds a bit worrying to me. What if a judge doesn't agree with using IVF for religious reasons? Judges have been well-versed in the law and experts at looking at the facts before them, and also looking at previous judgments, and not their personal religious views. There is a case called Besley and Wesley Monash IVF. In July 2009, Mr. Besley was diagnosed with cancer and advised that chemotherapy could make him infertile, and so it was recommended that he donate some sperm, which he did a couple of weeks later. He and his partner planned to have more children. His prognosis was good, and so he made no plans of what to do with the sample if he died. The center said they recommended that he do so, but his partner said she didn't remember them pointing this out at the time. Oh, that's sad for them. What happened? Well, it wasn't good, but because of that case, the law was strengthened. In November, the cancer had spread. Mr. Besley and his partner married, and unfortunately, he died just after the new year in 2010. That was so quick. So, they never had the chance to have a child after that. What happened next? The guidelines and policies that the IVF Center followed said that because Mr. Besley had died without leaving instructions for after his death, the 6 straw samples they were storing had to be destroyed. Really? Just like that? They wrote to Mrs. Besley explaining that without written instructions from her husband, clarifying his wishes should he die, they were obliged to destroy his samples unless she got a court order. She sought legal advice and commenced proceedings to stop this from happening. She was still paying a fee to keep the samples stored. It went to the Queensland Supreme Court later that year. She had to take them to court. That's terrible. I'm not sure I could go through all that. It's hard enough trying to have a baby. Isn't that my right? There are no property rights over people, but there are some rights over human tissue, and I can understand your concern. The decision in this case was in favor of Mrs. Besley, and it made the law more defined in terms of ownership and property rights. In order to come to a decision, the court looked at other cases, including cases from overseas. The judge found a number of authorities recognized that some human tissue, or body parts, can be capable of being subject to property law, and that the law can be rightfully protected and apply remedies. The judge even commented that common sense in Mrs. Besley keeping the terms of Mr. Besley's agreement with the center was a factor in the decision. After all, she not only kept the terms of the contract of her husband with the center, she had also been paying the agreed fee for storage, and so the center had to honor the agreement under the court order. That ruling was made because the center had a relationship with Mr. Besley. When he died, his representative, which is Mrs. Besley, took ownership of his property. This was seen as a bailior and bailee relationship. It means a temporary control of the possession of personal property by a person known as the bailior, Mr. Bastley, into the hands of a bailee, Mrs. Bastley, for an agreed purpose. It's considered to be a contractual relationship since they have bound themselves to act a certain way. The bailee receives only control or possession of the property while the bailior still has ownership. During the bailment period, the bailee's interest in the property is superior, even to the bailior, unless they violate the terms of agreement. Once the purpose has been accomplished, the property will be returned to the bailior or disposed of, according to the bailior's instructions. Mr. Beasley died, and as his representative, Mrs. Beasley owned that property. This is an important case, and we are all learning. Changes in policies and procedures take place to reflect what is appropriate and to safeguard the well-being of all involved. This case makes it clear that you and your partner can and should clearly state, in any agreement, what your wishes are in all circumstances. The clearer, the better, to avoid any assumptions or misunderstandings. Yes, that is something we would want to do. I think it would be a good idea to look at all possible factors and make a decision together. So Mrs. Beasley has property rights over the samples and can maintain ownership of them. Have I got that right? Yes, the judge said as long as the fee for storage was paid, she had the right as the current owner of what was his property. He said the center had to store the sperm for 3 months and that the case could be revisited by either party if they wished. It looks like the case's weakness was there was no legislation to back up arguments. What a shame she had to go to court to claim her rights. I'm happy it worked out okay for her in the end, but it seems like there's a fault somewhere in the legislation, or lack of it, if it takes all that effort to have your rights honored. I can see your point, but the strengths of the case were numerous, relevant cases, to help to define and clarify classifications of property law. Also, the cases the judge referred to had already interpreted the meaning of personal property. The judge applied those principles to see if they were relevant in the Beasley case. The judge's reasoning and analysis of the case followed the same path as the other cases that were referred to. In your circumstances, you and your partner would maintain the property rights of any material that has been donated or created. You can give very specific instructions in your signed agreement which would be binding. The way that medical science and technologies are developing, I guess the law on human tissue will have to develop further and adapt to the current-day lives of people and their circumstances. These changes would help clarify property rights to secure all human tissue under legal ownership and property law. I suppose that the more cases there are, the more defined property rights will be. I think if the common law were strengthened and clarified by Australia-wide legislation, people would feel secure and know exactly what their rights are. Otherwise, it seems like a backwards-thinking way of doing things. Do we always have to wait till there's a problem and then go about fixing it? Why can't we just think ahead about what might happen and put laws in place to protect people's rights when it does? It would be so much easier. Although, I know my partner thinks that too many laws mean there's no flexibility for unique individual circumstances. You can't please everyone. That is certainly true.
I never thought of property in that way. It makes you think, doesn't it? We often don't question things in our everyday lives until they become a problem. I hope Sally and Philip will be okay. It sounds as though the Beasley case outcome supports their ownership rights, and they should definitely think about all the circumstances that could happen to them.
You know, Philip, he'll be right onto it. No stone left unturned before he signs anything. I think they'll be just fine.